debate, discuss, decide. We're the only organization on campus that's hosting debates as of now, so you came to the right place if you'd like to hear, like to enter the marketplace of ideas. We're excited to have two excellent speakers with us today, and I will turn it over to Maddie Stein, our operations chair, to introduce our speakers.
Hi everyone, thanks for coming. I am honored to introduce our two speakers in today's debate, Professor Stephen Vladeck and Professor Josh Blackman. Professor Vladeck teaches here at Texas Law. He is an expert on constitutional law, federal courts, national security law, and military justice. He frequently appears on CNN as a Supreme Court analyst. Together with Professor Bobby Chesney, Professor Vladeck co-hosts the popular National Security Law podcast. He attended Yale Law School and clerked for judges on the 9th and 11th Circuits. Professor Josh Blackman teaches at South Texas College of Law. He is an expert on constitutional law, the intersection of law and technology, and the Supreme Court. Professor Blackman is the author of the critically acclaimed book, Unprecedented, the Constitutional Challenge to Obamacare. He is the founder of the Harlan Institute and Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
You should all play. First Monday was yesterday. Go sign up. It's time. Now it's time to play.
It's all good.
Professor Blackman is a graduate of the Antonin Scalia Law School. He clerked for judges on the 6th Circuit and on the Western District of Pennsylvania. So the format of today's debate, each speaker will have 10 minutes for an opening argument, and then followed by the openings, they will address each other's arguments, and then that will be followed by Q&A. Please join me in welcoming our speakers.
Thank you so much. It's always a pleasure to come to UT. Indeed, I often see my former students here, which is always a treat. The topic today, and this is a title that Steve proposes, have federal judges join the resistance against President Trump. Oh, Steve, hand me my clicker, please. It's right there. Thank you. See, we're always helping each other out. We had originally scheduled this debate for last spring, but we had a scheduling conflict and it didn't work out. So I'm grateful we were able to make this happen. So the topic is, have federal judges joined the resistance against President Trump? The origin, I think, of this debate stretches to a piece that Steve wrote in the New York Times with Dahlia Lewithwick. She is a columnist for Slate. And the piece is titled The Dangerous Myth of the Judicial Resistance. This was published last October. The piece names me and at least one or two other people as doing something very dangerous. They wrote that my criticism of some of the judges who have ruled in the travel ban cases were dangerous. He cites one of the National Review pieces, and they write, to these critics, these judges aren't real judges. They're partisan hacks in robes. He names me, he says, Professor Blackman wrote in National Review that judges have abandoned their traditional role out of a fear that Donald Trump posed an existential threat to the Republic. I did write that. And he did. And then he writes, it's dangerous new ground to cast judges who rule against the president as unprincipled frauds. They said there was no effort by Obama supporters to discredit every single judge who ruled against the administration. There was some stuff I can maybe bring that up during the debate. But here's where we come to the crux. Discrediting federal jurists as having joined the resistance isn't merely an argument lacking in support. It's profoundly dangerous. Then he closes. We might expect these kinds of broadsides from those who see no value in the rule of law. But dismissing every jurist with whom you have a disagreement as an unhinged partisan, me, I think.
No, the judges.
Oh, that's a poorly constructed sentence.
Dismissing every jurist with whom you have a disagreement as an unhinged partisan?
Represents. See, I thought that referenced my criticism of the judges. Okay, fair enough. Poorly constructed sentence, but I'll give Steve the charitable benefit of the doubt. See, it took him 3 minutes to interrupt. Actually, it's pretty good. I was expecting sooner. But then we come back to the crux, right? What is this judicial resistance? Is it a myth? Is it dangerous? So the first point, I actually want to make a ground of agreement with Steve. Some of my colleagues have written things that are similar to what I've written, but that I haven't actually written. I don't think that these judges are unhinged partisans. I don't think that they're hacks in robes. I think that these judges are indeed acting with well intentions. They have good faith. I think they've made profound errors of law, which the Supreme Court's decision in Trump against Hawaii, I think, clarified. But I don't think these judges are partisan. But I do think something is going on. And the basis of this theory is not something I came up with myself. Back in March of 2016, on the Lawfare blog, which you should all read, Steve is a contributor, Ben Wittes and Quinta Juracek wrote a very, I think, profound piece. And they wrote, "The Revolt of the Judges. What happens when the judiciary doesn't trust the president's oath?" And I read this and it actually had an impact on me. And Ben and Quinta made this point. They said that some of the judges ruling against President Trump and the travel ban were behaving in ways that haven't been done before. And they write, I'm going to read this point verbatim, "It goes, not to put too fine a point on it, to the question of whether the judiciary actually means to treat Trump as a real president, or conversely some kind of accident." Like a Forrest Gump, right? A person who somehow ended up in the office, but is not quite the president, in the sense that we previously recognized. And that resonated with me, okay? So that's what Ben and Quinta wrote. Now here's what I wrote. I wrote a piece in National Review called "The Legal Resistance to President Trump." This piece was primarily about the legal resistance. Now, who is the legal resistance? This is a self-professed movement. Shortly after the 2016 election, a hashtag, that's what we communicate now, a hashtag emerged, hashtag resist, or hashtag resistance. And this was a broad political movement. And again, I don't think there's anything wrong with this movement. When you lose an election, you turn to the courts. Republicans did it for 8 years with President Obama. They sued every 5 minutes for everything. So there's nothing wrong with it. But what surprised me wasn't merely the sorts of lawsuits being brought. What surprised me primarily was how the courts reacted to those lawsuits. So I drew a distinction, maybe it's too fine, between the legal resistance and the judicial resistance, right? I think the lawyers are bringing their arguments in good faith. I think the judges are making their cases in good faith. But I do think that there's two distinct phenomenons, okay? But here's the key point, right? When we're talking about judges, I try as hard as I can to say that they are well-intentioned. In fact, in the piece, which I wrote verbatim, this approach is well-intentioned, but flawed, right? So let's actually talk about what I mean by the judicial resistance, okay? The first point is I think the courts hadn't afforded President Trump in these various cases what is commonly called the presumption of regularity, okay? What's the presumption of regularity? This is the idea that when the executive branch, and particularly the president, takes certain actions, you have to afford it a presumption that's taken in a good faith manner. Many of the judges who ruled against President Trump in the travel ban simply disregarded that presumption. And the sorts of rulings they issued would disable the president from exercising wide swaths of his own authority. And to give you a very simple example, if you focus on campaign statements to say the president shows animus towards this group or that group, you've now said that now the court can intervene whenever the president takes any action to affect those groups. The president has certain foreign policy powers that require him to engage with those groups, but a court can say, no, you cannot do this. So I think the first way that these courts, I think, erred was by failing to give the president this presumption of regularity. The second approach was, I think, an eagerness to resolve very difficult constitutional questions in the realm of national security. Now, it's certainly true, right? The Constitution doesn't give a blank check to the president in the realm of national security, right? We can all agree on that. But the actions that were taken were afforded and given, I think, what you call a rational basis to justify them. And courts simply second-guessed that and dismissed that. Indeed, some judges even demanded confidential memorandums to assuage their own concerns. And that's something that I don't think we had seen beforehand. And the third aspect, I think, of this judicial resistance, as it were, is a charge the president's acting in bad faith, and not just the president, but also the government lawyers who defend his actions in court. Again, I don't think I invented this theory. Perhaps it's attributed to me more often than not, but I think this is a developed theory as far as they go of how the courts behaved in the first year of the Trump administration. Right? And then to reiterate this, and I want to make this point very clear, I don't think this is a partisan issue. I really mean that in my heart of hearts. I think these judges are well-intentioned. They think that they're serving their role in the separation of powers. They write opinions with citations and law. I think they cover all their bases. But I want to conclude with the travel ban decision Trump against Hawaii decided about 3 or 4 months ago. And on the eve of the arguments in Trump against Hawaii, the Washington Post published a feature by Robert Barnes, great reporter. And the title was, in the travel ban case, Supreme Court considers the president versus this president, right? Are we going to rule on this based on what President Trump is or based on what the presidency is? And Chief Justice Roberts' opinion chose the presidency. And he says this: we must consider not only the statements of a particular president, but also the authority of the presidency itself. And that's largely what's motivated my thinking in this entire topic. I'm not a Donald Trump fan. I didn't vote for the guy. I'm not planning on voting for again in 2 years. I think his policies are pretty awful. But I care very deeply about the separation of powers. And when I think that judges are not affording the proper deference that is due to the president, I think it's worth speaking out on. If you want to read more, I have a piece called On the Judicial Resistance, which replies to Stephen Dalley's op-ed, published last February. I think my time is up. I will sit down, and I welcome your questions. Thank you all so much.
Okay, first let me say thanks to Josh. Among lots of other things, Josh is always a good sport. And I think now more than ever, it's important to have people who respectfully disagree with each other, even if they disagree all the time. So let me start with the Josh portrays this as what I take to be his initial charge, that Dahlia and I in our New York Times op-ed had unfairly associated him with some sharper comments from some of his colleagues. As I think you saw in our exchange, I think that might have been based on a misreading of what we said. But leaving that aside, I think it's worth stressing that this did not start with our op-ed. Right, that Josh had been writing for a while, criticizing judges in the travel ban cases. Ilya Shapiro from the Cato Institute, who was here last week, had a piece in May of 2017 titled "Courts Shouldn't Join the #resistance." The Wall Street Journal's editorial page and op-ed page had both published pieces basically criticizing lower court judges for joining the resistance. So I don't really think that it's fair to say this all started when Dahlia and I criticized these existing writings. I think it started with this claim that the courts were actually treating President Trump differently from other presidents. And why does that matter? So let's take the travel ban as a good example, since that was Josh's example. Josh quoted from Trump versus Hawaii, the Supreme Court's decision in June, where the court did indeed uphold President Trump's travel ban. But let's be clear on what the court upheld. The court upheld travel ban 3.0, right? Not 1.0, not 2.0. What happened to those? Those were struck down by the same lower courts, of which at least Ilya and the Wall Street Journal, and I think Josh, but he can clarify for us, were very critical. Why weren't those decisions challenged in the Supreme Court? Right? If the lower courts had joined the resistance, why didn't the Trump administration take the lower court decisions invalidating travel ban 1.0 and 2.0 all the way up? Well, here's what happened. With 1.0, after they lost in the Ninth Circuit, the Trump administration went back to the drawing board and rewrote the executive order rather than go to the Supreme Court. To me, that's not a sign of courts joining any resistance. That's a sign of the executive branch realizing when it had lost. Right? With 2.0, the case actually did go to the Supreme Court, but through some pretty clever tactical lawyering by the Solicitor General, the government was actually able to prevent the Supreme Court from ruling on the merits over the course of the summer of 2017 until the government had time basically to modify the executive order to give us 3.0, which was issued in September of 2017. At which point all the Supreme Court says is, hey, lower court decisions, you guys are dealing with an older version of the travel ban. We're not going to worry about that. We're going to set those aside. We're going to start over. Right? So the narrative that starts with Chief Justice Roberts' majority opinion in Trump versus Hawaii misses that the very lower court decisions, of which at least other commentators were quite critical, and were using to illustrate that judges had joined the resistance, had in fact been followed, right? Had in fact been incorporated, responded to. If your concern is that the lower courts are acting unfairly towards you, agreeing with them seems to be an odd way of manifesting that concern, right? Incorporating their conclusions seems to be an odd way of manifesting that concern. More generally, right, I think this is the larger point of this debate. It's one thing, right, to think that courts have gotten it wrong. We're in law school. We think courts get it wrong all the time. Have you guys had a single class where your professor thought every decision was correct? Okay, right? This is what happens. The question is, what is the line between the decision with which you disagree and a decision that actually raises concerns that the courts have lost their robes, right? That they're acting as partisans. And that's not my language, right? That is Josh's language.
I don't use that language.
Let me read to you from your NRO piece. I really didn't want to go into this, but we can do it this way. Right? So in Josh's National Review piece, let me pull this up. The legal resistance often repeats the refrain that our polity must resist normalizing Trump as president. Courts, unfortunately, have followed the lead. When judges treat this president as anything other than normal, such as when they engage in law office psychiatry, it sends a signal to the public that the chief executive is not as legitimate as his predecessors. Trump was elected through the same constitutional process by which judges receive their lifetime commissions. He should be treated as such. It is true that Trump consistently disrupts all political norms. The court should not respond in kind by disrupting judicial norms. All right, so you didn't use the word partisan.
No.
But you do claim that the courts have disrupted their norms.
Yes.
Right?
Yes.
Is this my turn or is this your turn? Okay. Right, and the idea that courts are acting not like courts. That courts are doing things they wouldn't do in the normal course of business. That courts are hearing cases in ways they wouldn't normally hear them. And I guess my concern with that is twofold. First, I think it's wanting for evidence. With regard to wanting for evidence, right? Let's keep in mind that some of the actions that have been challenged by President Trump, whether they're lawful or not, are certainly novel. We had not, in American history, had the kind of mass suspension of entry that we saw with the travel ban. The Supreme Court upheld it, fine, but it was novel. We have not had a president who all of a sudden, with one sort of 280 character tweet, banned transgender individuals from serving in the military. That's kind of novel. We haven't had a president whose relationship to business interests raised serious questions about the domestic and foreign emoluments clauses, whatever those answers are. And so I think we have to be careful to not associate the existence of a judicial decision the likes of which we haven't seen before with the assumption that the courts are, in Josh's words, disrupting judicial norms, as opposed to just trying to do their best with new facts and with a new kind of executive branch action. And why am I so impassioned about this? I mean, so I don't think it will shock anyone in this room to know that my politics are adverse to those of President Trump's, but it's about something different from that. Those of you guys who were here last week for the debate about stare decisis, right? My real concern at the end of the day is how we perceive the legitimacy of the courts. Do we see the courts as simply another iteration of the political branches, or do we see the courts as doing something distinct from what our elected officials do? And when you have commentators basically looking at every lower court decision against President Trump as some sign that the courts have, again, right, not applied their normal norms, abandoned their usual norms, that's an accusation that the courts are acting in a manner that is non-judicial. And what leads me to worry about that is suppose that the Supreme Court had actually come out the other way in the travel ban case. Right? Suppose the court had ruled 5-4 in favor of Hawaii. Well, now you would have all these commentators saying, oh, the decision's illegitimate because the Supreme Court wasn't acting like a court. And I get very nervous about going down the road where we define legitimacy of decisions and adherence to judicial norms by whether we think the court got it right or not. It seems to me that if you're going to advance the claim that the courts have joined the resistance against President Trump, which even if it's not Josh's claim, is certainly the claim of others in the conservative commentary act, right? You need to have some evidence that they're actually acting in ways that other judges wouldn't at different times, right, faced with the same cases. Because otherwise what you're suggesting is the best evidence that courts have joined the resistance against President Trump is that they have the temerity to rule against him. And that to me is no way to run this particular railroad. Thank you.
Thank you. Very good. Well, again, let me reiterate Steve's comment. We live in very harsh times, and it's always helpful to have a good faith disagreement with someone you can sit at a table with. So let me make a few preliminary remarks.
It's a wide table.
No. Steve's a tall guy, by the way. That's why I stand up when I'm next to him, like his little Oompa Loompa, right? A few remarks. You know, Ilya Shapiro is a really good friend of mine. We agree on a lot of things. He used language that I don't approve of, and I'll say that very candidly. I actually reread his Cato piece that Steve quoted from this morning. I was like, wow, that went a little bit further. The second point I want to make is that I don't speak for the Wall Street Journal editorial board. I speak only for myself. I work very hard in my writing not to call judges partisans in robes. If I slip once in a while, I can apologize for it, but I try hard. My focus is on the word that Steve used, which is disrupting judicial norms, what I would call the presumption of regularity, right? How do courts usually speak and treat the executive? And shortly after the first round of decisions in the travel ban, I saw things that I really hadn't seen before. The very first judge rule, by the way, I agree with Steve on travel ban 1.0. It was a disaster. It was basically drafted in the back of a cocktail.
And not entitled to the presumption of regularity?
I didn't say that. So I can address travel ban 1.0. The first version of the ban was supposed to be a temporary policy to last, I think, was it 60 days or 90 days, whatever it was. It was poorly drafted. And perhaps the biggest failing of the first version of the travel ban was that it applied to lawful permanent residents as green card holders. Now, if you have a green card, you have a legal right to enter the United States. You can't be denied entry. I think that alone rendered it probably unlawful. I think you could probably read it to carve out LPRs. But the basis of the travel ban 1.0 was on certain statutory authorities. And Congress passed statutes saying the president has the authority to deny entry to aliens that he deems detrimental to American interests. There's another statute that says you can't discriminate with respect to issuance of visas on the basis of nationality. The first raft of decisions that ruled against President Trump basically ignored the statutory questions. In fact, they ruled on due process grounds. What is even the argument that there's some sort of liberty interest that people have in family unification? That argument disappeared very quickly. The first round of decisions against President Trump may have been right on the outcome, but were so poorly lacking in reason, where they didn't actually go through the statutory arguments. They said, wow, courts have an obligation to say first, is there a way to resolve this on statutory grounds? Instead, they leapt to resolve very difficult constitutional questions, looking at statements made by the president on Twitter. Now, he's right. Trump is novel. He does things that are new, that have never been done before, and I'm not going to argue there. My point only is that they did not afford the president the sort of deference and the sort of usual approach of reaching constitutional questions I think would be appropriate. I think there was this concern that Trump is doing something very dangerous, and I think the travel ban is a dangerous policy, but that has to be stopped. I think the political process is far well more suited for this in the long run. But the courts in the first run, I think, were not behaving the normal deference you should give to the president.
So I just want to say, I mean, the title of this debate is not, does Josh Blackman think the federal courts have joined the resistance?
The answer is no. Yeah, I don't.
Good, right? What I'm responding to is the prompt that Josh has echoed, if not in the same language. And so let me just read a quote from an op-ed in the Wall Street Journal by David Rifkin and Lee Casey. This was with regard to travel ban 2.0. It is therefore difficult to avoid the conclusion that the Fourth Circuit and the other courts that have stayed Mr. Trump's executive orders on immigration are engaged in the judicial equivalent of the resistance to his presidency. Judges are, in effect, punishing the American electorate for having chosen the wrong president. That sounds partisan to me. That is not the judiciary's role. Every federal judge has an obligation to accept the limitations imposed by the Constitution on his power, to exercise neither force nor will, but merely judgment, as Hamilton put it in Federal 78. Right? So I'm trying to, there's a real claim out there, whether Josh does not hold it as dearly as some others do, that the federal courts have in fact joined the resistance. And what I'd like to try to get to today is why I think that's not an appropriate claim, is why I think it's undersubstantiated, why I think it fails to account for the novelty of some of the questions these courts were faced with. It fails to account for the extent to which many of these decisions are being penned by judges who were appointed by Republican presidents, and who presumably would not necessarily be reflecting partisan vibes in that direction. And guys, more fundamentally, it misses the way that this litigation works. So Josh criticizes the early travel ban rulings for being, I don't remember your exact words, I don't want to misquote you, but if this is an unfair paraphrase, correct me, under-theorized and under-explained. Fair? Well, it was on a temporary restraining order. I mean, the fact that the judge wrote a 7-page opinion accompanying a TRO was a novelty unto itself. So I guess what I'm trying to say is I think there is an understandable impulse on both sides to react to President Trump with hysteria. Right, that everything is extreme, either the wrongness of his actions or the wrongness of the reaction to his actions is all bad. And what I'm trying to suggest is I actually think for the most part, the federal courts have done pretty well dealing with the novelty that has arisen from this administration. One last thing about the presumption of regularity, because now I want to throw it open to questions, because I suspect you guys have some questions. So the presumption of regularity, this is sort of a nerdy administrative law point. How many guys have taken or are taking admin?
Take Steve if you can. Good class.
Well, yeah. So I see 3 hands. This is a Federal Society event? Wow, okay. We have
One of
some
my former students up there, by the way.
Okay, hello. So the presumption of regularity is the idea in administrative law that we assume, all things being equal, that the government followed normal process when it promulgates new substantive rules, right? That the I's were dotted, the T's were checked, okay? There are contexts in which there are serious debates about the presumption of regularity. If you want to read a really interesting judicial opinion on when it's appropriate, when it's not appropriate to apply the presumption of regularity, the DC Circuit has a Guantanamo detainee case called Lateef versus Obama. And the question there was whether the presumption of regularity should apply to an intelligence report produced in the field in the midst of combat operations. Right? Are we really going to assume that that report has the same sort of hallmarks of normalcy and authenticity that come with a report issued by a government functionary in a windowless room in Washington? And there's a fight, and it's not a Trump fight. This case was back in 2012. Right? There's a fight between the majority and Judge David Tatel in dissent about when we do and don't apply the presumption of regularity. And one of the points that Judge Tatel made in his dissent is the presumption of regularity is something the government earns by dint of following normal procedures when it changes policy. It's why we have notice and comment rulemaking under the Administrative Procedures Act. It's why the Due Process Clause actually requires process before the government moves to deprive you of life, liberty, or property. And so I guess the question is, if you look at, as I think Josh rightly concedes, travel ban 1.0, I think any reasonable observer should have concerns about whether that was regular, whether the means by which it was expounded, the means by which it was implemented, the means by which it was constructed, deserved the presumption of regularity, having nothing to do with the fact that it was Donald Trump's signature on the executive order, and everything to do with the lack of process the government went through in promulgating it. And it's part of why it fared so poorly in the courts. So listen, the point I'm trying to make, guys, is I think the claim that's out there that judges have joined the resistance is a superficial shorthand claim for judges are issuing decisions that we don't think are correct based upon this administration's approach to these issues. And I'm perfectly happy to accept that debate. I mean, I know enough to know that plenty of judges disagree with most of the things I hold dear.
We actually agree on Marbury, by the way.
Which part?
Yeah.
Right? But the key to me is let's have that conversation. Let's talk about exactly what you thought was incorrect and unavailing about the decisions you disagree with, as opposed to dismissing them as just judges joining the resistance. Because here's the problem. At the end of the day, if we get to a point in this country where we look at all judges as partisans, and after last Thursday, I fear that we're getting there faster than maybe we had expected, right? Why should anyone follow a decision they disagree with? Where does the court's moral authority come from, if not from the belief that they're not just partisans and rogues? So, I'm not immune to the idea that there could be contexts where judges abandon their norms. I'm just not sure we're there yet.
I think Steve and I largely agree, and this is quite cathartic. I also worry about how the courts are perceived. I'll caveat a little bit, it's a two-way street. If the courts are perceived as illegitimate, people don't follow their decisions. But what leads the court being viewed as perhaps illegitimate? Now, I've written, at this point, a book-length treatment of why I think the travel ban decisions are wrong in many respects. And substance, I can argue for hours. That's not my point here today. But if people see the courts in a certain fashion as using slapshot reasoning to stop an executive order for which the president has vested authority, that's also problematic. The 7-page decision that was referenced had, I think, about 3 sentences of actual analysis. So it was mostly boilerplate. And if you want to read an actual emergency injunction, look at the Youngstown District Court decision. That was a lot. There was some substance there. And I think by the time the district court ruled in Seattle, I'd already written basically like 8,000 words in the case. And I think the judge could have done a little bit better. But I think in large part, Steve and I are on the same page. I also have concerns about the court being viewed as too partisan. I don't think what happened on Thursday helped the matter at all. It really boofed up the situation, you might say. And it See, I got him to wins. And it's a good time to break for questions.
All right, that was almost funny.
Yeah, come on. There we go. All right, let's do some questions.
We've answered all your questions.
By the way, I didn't know what that word meant. I had to actually Google it. I had no idea what that word meant. I guess I'm too much of a prude. I'd never.
You're too young.
I am too young, I guess.
Okay, so you two have been talking about the substantive issues, but I suppose moving to a somewhat more procedural point, the one that Justice Thomas brought up in his concurring opinion. What do you think about the use of the nationwide or the universal?
Oh, now it's on.
Right.
All right, so
I think we're both on record about this, but you can.
So I have no problem in the abstract universal injunctions, right? I think they're actually, to the extent that the rules of procedure permit, now just take a step back. There's no federal rule of procedure that says you can have a nationwide injunction. There's something called a class action, Rule 23, but there's no rule saying you can have an injunction binding all parties everywhere. But they've been done for a long time, not just with Obama, they were done even before that. So to the extent that they're okay, I think the travel ban was an appropriate use. Let me explain why. Imagine a person enters from one of these banned countries through, LaGuardia Airport or Kennedy Airport in New York.
It'd be hard to enter through LaGuardia.
Yeah, it'd be hard to. So they enter through Kennedy Airport in New York, right? And the injunction applies in New York. Okay, that same person gets on a plane and flies to Dallas-Fort Worth and can be denied. I think it's no way of having an immigration system where you have an injunction permitting some airports, not others. So I think the travel ban is an appropriate place where you can have a nationwide injunction. Where I think they've gone far is in the sanctuary city cases. So for example, President Trump has told certain cities that with these sanctuary policies, we're going to deny you funding. Okay, each city has slightly different laws, whatever they have. One judge in Chicago entered a nationwide injunction saying, you can't withhold the funding anywhere. That I think goes too far, right? When you have a city with specific laws, you can localize the injunction to that specific jurisdiction. And I don't think there's any reason why.
The city doesn't move, whereas the immigrant can.
Exactly, yeah. People are mobile, geography is not. Now there's
the metaphysical side.
If we could move Austin out of Texas, no, just kidding. I think they may.
Where do I sign up?
Move it. If we could move Austin to Stamford, Connecticut, that would fit very well. But let me answer the other question. Maybe it's more
Connecticut?
of an Yeah. The admin law question, though, I think is actually more difficult. There was one ruling on the DACA case from Judge Bates in the District Court of Columbia, and there's a question of whether a set-aside by a federal court saying that this is arbitrary and capricious acts as a nationwide injunction. I think there's also a question of whether that's appropriate. I think it's probably a more textually grounded approach than the straight-up, we're just issuing a nationwide injunction. Steve?
So I actually agree with a lot of what you just said.
Wow, look at that.
I think the nationwide injunction conversation is infected by a whole lot of hysteria and hypocrisy. So on the hysteria front, the nationwide injunctions that I understand to be in effect right now are all against the government, right? The federal government. There isn't a single nationwide injunction against a non-governmental actor that I'm aware of.
I can't think of any.
Off the top of my head,
yeah,
right?
I think of any.
And I think, to my mind, the government is a different actor than a random defendant, right? Because the government, in theory, has the power to act everywhere. And so right off the bat, I start from the concern that when we're talking about the federal government, I didn't know that it's so obvious that we actually want the specter of 94 different sets of rules, depending upon which district court the case is brought in. The Attorney General is fond of making the argument that nationwide injunctions are unconstitutional. I think that's almost frivolous. Right? That is to say, the claim is that federal courts lack the power to bind non-parties to litigation. That is overly simplistic and superficial. There are actually plenty of contexts in which decisions by federal courts at least have the effect of binding non-parties, if not such that they come with penalty of contempt. I think the real problem with nationwide injunctions is that they've become too commonplace, right? I think that there ought to be careful limits on when they're used, and also that we've lost sight of why they've become too commonplace. So Josh mentioned class actions. Part of why nationwide injunctions have come into vogue in recent years, there's some history going back to the 6th, but is because it's become so much harder to to certify a nationwide class action. Right, and it's become so much harder, I don't think I'm speaking out of school when I say, because of opposition from mostly conservative judges to the standards for certifying nationwide classes. So to me, right, you have to understand how these things, you knock down one, you whack one mole, it pops up somewhere else, right? The nationwide injunction thing is a reaction to how difficult it's become in other contexts to obtain what we would have agreed previously was appropriate nationwide relief. That doesn't mean that they're justified in all these cases, but it does mean that I think they're not quite the horrible thing they're made out to be whenever you see one. Josh mentioned the Sanctuary City case. It's interesting to talk about the government's litigation tactics in that case. So the government lost in the district court on the merits and then got a nationwide injunction. They appealed to the 7th Circuit. They lost in the 7th Circuit, and the 7th Circuit also affirmed the nationwide injunction. They then sought rehearing en banc, not on the merits, but just on the nationwide scope of the injunction. Yeah. So the government is saying, you know what? We concede, right? The sanctuary city policy is unlawful, but we just want to fight the nationwide injunction. And my reaction to that is, well, wait a second. If you concede that the sanctuary city policy is unlawful, aren't you conceding that it would therefore be illegal for you to apply it anywhere in the United States? And if that's true, what is the harm from the nationwide injunction? So this is what I mean by like hysteria and hypocrisy, right? I think that there are concerns about overuse of nationwide injunctions. I would be very worried about using them against non-governmental actors. But I think that I'm not sure that the public discussion sort of is consistent with what the real problems on the ground are.
And let me add one point. The biggest cost of a nationwide injunction is when it's not stayed. And it creates a potential issue where you have what can be called dueling nationwide injunctions, where a district court in one state, Texas, issues a decision on one way, and a district court in, say, California goes the other way. And that puts the executive in a bind, right? Which one to follow. I think ultimately the Supreme Court's going to have to intervene because this has forced them to intervene at early stages. Courts like percolation, right? They like when things, circuit splits, they marinate, they sort of, go for a while. But when you have these raids to the courthouses, you're having these emergency stay motions filed at the court, and they don't like those very much. So I don't know if Congress will intervene. I doubt they can pass anything. The Supreme Court may put some teeth into it if the sanctuary city issue from the Chicago one goes up, which I think that's the vehicle the government wants. The government wants sanctuary cities because Steve's right, cities don't move. They're stationary, whereas I think people do move.
I will just say, I think it's telling that no other justice joined that part of Justice Thomas's concurrence in the travel ban case.
Yeah, I mean, it wasn't, Justice Thomas likes issuing opinions that are, reaching issues that are not present because the court ruled against Hawaii. So yeah, there was no reason to reach the issue because there was...
That hasn't exactly stopped some of the other conservative...
Yeah.
Just saying.
Yeah, just saying. All right, what's next? Who's other questions? Oh, come on.
Boo.
No, there's got to be something else. Yeah, in the front row.
There's like discussion about to what extent you have to, I guess, rule based on the position of president versus the president in office. Obviously, like, there's arguments, I guess, either side, but is there a limit to, I'm saying, like, even more extreme conduct where it's just like blatantly outrageous? Is it just up to Congress to be the one to step in, or do the courts have any reprieve, or are they all supposed to intervene?
So, I mean, there's an example I like to use I think is less fraught with the politics of the moment. Well, no, it's somewhat less fraught. So in the military, there's something called unlawful command influence. And unlawful command influence is when any commander does something that calls into question the impartiality of those participating in the trial process. So that can mean the prosecutor, the defense lawyer, the defendants, witnesses. I mean, it's military, so there's lots of axes for control. There was an episode not so long ago when a president made some stray comments about sentences for sexual assault cases. And those comments were used by a bunch of military judges to actually impose as proof of unlawful command influence. and as a justification for imposing lighter sentences in sexual assault cases. That president was Barack Obama, right? And so I use that example to sort of point out that presidents can get themselves into trouble, even if their name is not Trump, through things they say. Because as the chief executive, they are oftentimes either a commander in the context of military justice, or the head of the executive branch in the context of interpreting and applying the laws that the federal government is enforcing. So I guess I don't see as much daylight as the Chief Justice did in the travel ban case between the president you have and the presidency. Right, that I think the Supreme Court obviously has to be thinking about the presidency as an institution, but that sometimes that means you have to rule against the president you have. So take as an example the Nixon case, right, the Watergate tapes case. I teach that case in common law as a case where Nixon lost, but the presidency won. Why? Because in the process of holding that President Nixon had to turn over the Watergate tapes, right, tapes that basically led to his need to resign, the Supreme Court nevertheless recognized for the first time that the Constitution protects executive privilege. Right, that executive privilege is actually in the Constitution even though it's qualified, and that it generally protects the confidentiality of executive branch communications. So it seems to me the Supreme Court is capable of drawing distinctions within cases between the president and the presidency. They did it in Nixon. And so I don't know why the travel ban case bothered me, because if the chief really believed that he was applying ordinary minimum rationality review, what the president said should have been no, never mind. Right? And then he went out of his way to say, I'm going to acknowledge it, and then say, but it's not controlling, I think was worse than saying nothing about it.
Yeah, I'll pick up where Steve left off. The government, the Solicitor General, actually urged the court to go deeper than the minimum rationality review. They said, we want you to peek behind the curtain. Think of the Wizard of Oz, right? Who's the man behind the curtain? And they said, look behind the curtain. And it actually got the SG, I think, into a little bit of trouble because he made some statements that, characterizing the president's statements. And I think the court said, on our own initiative, we're not going to go diving into press statements because that's not the sort of things that we want to do. Had the court come out the other way, if it went 5-4 for Hawaii, I think that would have sent a signal to the lower courts that yes, you can pour through the president's Twitter and you can pour through his campaign statements and use them to rule against the president. And had that gone forward, I think entire swaths of the president's policies would have been halted by the courts. We saw this, for example, in the DACA litigation. This, of course, concerned whether President Trump can terminate the DACA policy, this executive action for the Dreamers. And at least one or two judges said, well, President Trump made disparaging comments about Mexicans, and he threw Jorge Ramos at a press conference. And all these things manifest an animus towards Hispanics, so therefore the decision to rescind DACA is unconstitutional. I think that goes further than the travel ban, and I think that's the risk, where you start gleaning into peripheral areas of the president's statements that relate to a certain topic and using that to establish an animus against the president. We have one president, right? We only have one. If there's some low-level functionary who does something bad, he can be fired and replaced. But you can't replace the president unless you have an election every 2 to 4 years, or an impeachment perhaps. But I think you do have to treat the president in a slightly different fashion, right? No president's above the law, but I think the law that applies to the president in often cases is a little bit different, right? Most government officials have qualified immunity. The president gets absolute immunity. Most people can be subject to subpoena. In the U.S. v. Nixon case, there are certain limits on the subpoena. So there are certain, I have a paper called the Presidential Avoidance Canon coming out at some point soon in the future, but there are ways that courts treat the president a little bit differently, and I think Trump against Hawaii is an example of that.
But wait, can we distinguish though? I mean, it seems like, are you saying that the president's public statements should never be relevant?
I didn't say that.
I'm asking, right, and if the answer is no, they should sometimes be relevant, what's the answer for when?
So,
because, I mean, imagine a case, right? Imagine a case where the president says, I have verbally instructed, but not put into writing, right? He tweets, I have verbally instructed every senior executive branch official, no more Jews can be hired by the executive branch, right? And the only evidence we have of the president's nefarious motive is a tweet. Admissible? In the discrimination
and so
case?
the policy itself says no new Jews?
Well, the president's statement, right, which is the only manifestation of the policy, says no new Jews.
So I think post-inauguration statements are fair game. I think when you have a facially neutral statement, a facially neutral policy, I think, as the Solicitor General suggested, you can have these sorts of statements to show perhaps intent. I do draw the line, though, at the inauguration. I think that's an important point.
Even though, okay, so the president on the day before inauguration says, when I'm president, we will not hire any more Jews in the executive branch.
Well, Trump said basically that with respect to Muslims and immigrants. He said it very carefully and candidly several times. The reason why I think the inauguration...
And then look what happened.
Let me make my point, please. Let me finish. I think when you have a situation with the oath of office, I've described it as a constitutional baptism, right? You take an oath of office, you form a government, now you have a lot of people surrounding you, and you have certain responsibilities that a private candidate doesn't have, okay? Had President Trump said the exact same things that candidate Trump said, I actually think the travel ban analysis would probably come out a little differently. He changed his rhetoric. Now you say, well, he didn't believe it. He was just, keeping his mouth quiet. Fine. But when you have this sort of facially neutral policy, and the government comes forward with, I think, are credible defenses. They're not perfect. They don't have to be perfect, but I think they're credible defenses of why these 6 nations should have an entry ban. I think that's enough for the courts to defer. Now, again, the travel ban is a miserable policy. I think it's awful. I don't defend it in the least. The question, though, is far narrower about what the courts can do about it.
Kevin?
Yes, sir.
Oh.
So going back.
I'm sorry. We'll get that one next. Yeah.
Okay, going back to the travel ban case, what would you have had to see in the opinion, like if they still struck it down, to make you think that it was a valid opinion and not just resistance against Trump type stuff?
Well, so one thing that I think was worthwhile is the statute. And I mentioned the statute earlier. I had actually researched this question between November and January, right? I had actually put a lot of thought into this before the travel ban, because I was expecting it. So when the travel ban dropped, I was already pretty familiar with the statutory framework, which is why I was able to write so much crap about it in basically 3 days. When Congress passes a statute that says the president has the power to deny entry to those he deems detrimental to American interests, that's a very big delegation of power. In fact, I think that delegation may violate the non-delegation doctrine. Another topic for another day. But I think that might be even too open-ended for Schechter Poultry. Well, you want to really get nerdy, right? I think, but assuming that statute is constitutional, we have a situation where the Congress is giving the president all of his authority, and I think the president has, according to precedent, inherent authority to exclude. Probably wrong as original matter, but when you have statutory authority and you have your own inherent authority, that is where Justice Jackson in Youngstown would say that you have a very strong presumption of constitutionality, right? You're in the first tier of Youngstown. And that was what motivated a lot of my thinking in the first early days of this case. The first court that ruled against, the district court in Washington didn't even mention the statute. He just sort of ruled against it. And the Ninth Circuit, if I believe, basically said, well, we just find due process violation. They didn't really engage the statute. I think that was a mistake. In Hawaii against Trump, John Roberts, Chief Justice, spent a lot of time on the statute. Justice Sotomayor's dissent said, well, we're not going to talk about the statute because it's such an easy constitutional question. Okay, maybe that's right or wrong. But even Kagan and Breyer are somewhere in the middle. They didn't quite go one way or the other. The statute is where it gets, the statute here. Congress gave the president awesome power. Maybe he shouldn't have that power. In fact, I've said this publicly. I think Congress should rescind Section 1182 and modify it. Say the president can suspend entry for 90 days and then come to Congress for permission. I think that'd be better, right? But if Congress gave the president this much discretion and then we elect a person to exercise we don't like, that's the fault of the law, and that's not the fault of the president.
So you're saying that a decision that was on constitutional grounds against the travel ban would have seemed less resistancy to you than one that was on statutory grounds?
I think that if you fail to engage the statute, that informs your level of scrutiny, so to speak, right? If you fail to engage the statute. Now, again, there were, if it had been a straight-up opinion saying that we read the statute to say that this statute has a requirement that you can only exercise for a certain period of time, I'm okay with it. But just reaching for the really tough constitutional questions when there's a way of getting out in the statute, I think is wrong. I mean, if you look at Neil Katyal's brief, he was a lawyer for Hawaii, it's almost all in the statute, right? I mean, they focus almost exclusively on the statute. That's how you rule against the president, on narrow statutory grounds, not on the sort of really the media establishment issue.
So a disingenuous interpretation of the
I
statute.
didn't say disingenuous.
Well, you just said you did all this research about the statute, right? I mean, so you're saying that a ruling that relied on a reading of the statute with which you disagree,
yeah,
would have been less resistancy than a ruling based upon an interpretation of the Constitution with which you disagree.
You're trying to put words with resistancy. Is this a word?
I'm taking the question. I'm taking the question as it was asked.
I reject the premise of the question. One that I think would. Look, you can't put words in my mouth. This doesn't work like that. I think the answer is this. If you look at section 1152, I think there's a way of reading it to apply to Travel Ban 3.0. Why? Travel Ban 3.0 actually concerned the issuance of visas. And I think
agree with you.
Right, so I think it's a flawed reading of the statute. I don't think it's resistancy.
The question I'm
It's like a staff-resistant antibiotics. I don't know what that word means, resistancy.
What I'm asking is, so let me put it another way. If Justice Kennedy had written a majority opinion in Trump versus Hawaii that said, we agree with Blackmun on the statute, see his erudite, thorough reasoning here.
Thank you.
We therefore must reach this complicated constitutional question.
Yeah.
And we interpret the Constitution to find religious discrimination in this policy, even though we understand that reasonable people may disagree with us. And we do that not because we don't like Trump. We do that because we worry that a policy that has this impact and a policy that looks this way will be perceived. Now, you may disagree that that is the standard the court should apply to the constitutional question. But is that a decision that, in your view, would have been criticized as judges joined in the resistance?
If he wrote it in the fashion in which you just described, I don't think I'd have a problem with it. The problem I have was how district courts wrote. One judge wrote this opinion, the order was dripping with animus and this sort of really over-the-top approach, right? Again, resistancy, I'm not using that word Steve wants me to say, I'm not going to say it. Resistance, right? I'm not going to say it. But I think, and actually, so let's look at the Establishment Clause for a minute. I think there's a very good argument that the Establishment Clause historically is not applied to foreign policy. And I think the only court that could extend that would actually be the Supreme Court. I think the lower courts were out of line by extending domestic Establishment Clause cases to foreign policy where I don't think it expressly even applies.
So lower courts can't decide constitutional questions of first impression?
Oh, I think they can. I think lower courts can.
So why is it
they
beyond
should
the power of the
acknowledge?
lower
Oh,
court?
no.
You just said it. You said the lower courts were out of line in extending the Establishment Clause to
They
foreign
didn't
policy.
reconcile it with an entire body of law saying it doesn't apply. That's the problem. If the Supreme Court wants to say we're extending this doctrine, they can. Lower courts actually have to grapple with long-standing precedent in which our immigration law treats people differently on the basis of their nationality.
But not their religion.
The statute actually, I'm sorry, I meant religion, not nationality. Actually, the discrimination statute says you can discriminate on the basis of nationality, but not religion.
Right.
It's actually a weird card. Sorry, I flipped it. Thank you, Steve, for the correction. We have time? We have more time for questions.
Kevin, you had a question?
Yes, please.
Oh, I was just going to ask for you to expound a little bit more on why you think the standard should change on the day of inauguration. Meaning,
Yeah.
like, why is that such an important date for you? I feel like I got it.
Yeah, no, it's a good question. If you couldn't hear it, it's why should the standard change after the inauguration? When you take the oath of office, I think that's a very powerful moment. You've just assumed an office that's unique in our republic. There's only one. And you take unique oath prescribed by the Constitution to support, protect the Constitution. As a mere candidate, you don't have that. And I think by taking that oath, you now have taken on a responsibility that only 44, 45 people have ever exercised. And I think that's where the presumption of regularity comes from. It doesn't come from a mere campaign tweet. I think there is some significance to this post-inauguration moment. Anyone else?
I guess just
Yeah.
more on like the inauguration though. But like, so is your opinion that the intent or basis of an opinion can't form the basis of a constitutional challenge to that opinion? Or that the president suddenly morphs into an entirely different being of higher standing and power and mental acuity?
Well, I don't know about mental acuity in this case, but I do think that candidate Trump takes on a different persona as becoming President Trump. And for those 4 years, he has certain powers that the Constitution gives him. And one of those powers is the power to deny entry to aliens that he deems detrimental.
But why do we assume that his intentions change?
I think the point is more broadly, it becomes, I think, difficult to scrutinize the president's intentions based on things he said to try and get elected. And often can't, and he might sincerely believe them. You know, we can argue that, but I do think the campaign statements is where I would draw the line. I think that statements, for example, in the transgender ban case you've mentioned, I think the president's tweets are directly probative. In that case, they directly speak to the issue at hand.
Yeah.
Yeah.
With the question of you say that we shouldn't scrutinize their words more easily when we're challenging the policy because they're trying to get elected. Isn't it an election to decide the policy? So So should we use that even more supreme?
What does it say about Americans who elected a president that want to enact a travel ban? He won, and he gets that power. Yeah, maybe someone else who hasn't raised his hand. I mean, he was elected, right? And that's a policy judgment. Yeah, he was.
Right, so
To implement that policy, so should we look at?
Well, implement what policy, though? So this actually gets to a point that I think is worth addressing briefly, and people are filtering out, but I'll keep going. The president's policy did change. And he initially said a Muslim ban, then he said a territory ban. Maybe you believe him, maybe you don't think he actually changed his intent, but he actually did change what he actually wanted to, what policy he wanted to institute.
we had to make it legal, Giuliani said.
Actually, no, I want to address that quote. If you ever watch the full interview, and I actually spoke with Representative McCall. Is Austin McCall's district?
No.
Okay, but he's in this region. I actually spoke with Michael McCall. It was Rudy Giuliani, Michael McCall, and was it Mukasey who was the third one, or who was the former Attorney General? There were three people working on Trump's task force, right? And the way they describe, if you actually look at the full interview, was how to create a lawful ban for people in certain territories. It was not to a closet Muslim ban. Now, we can parse words in cable news. I go on cable news, Steve goes on cable news. I say things sometimes that I didn't mean to say. Words can be parsed. I think it's very tough taking, a Meet the Press style interview and taking word by word, parsing of it to try and figure out the intent of a policy, which is why I think this is an area where courts should be very cautious before they start jumping into the archives of CNN and Fox.
Do you actually believe that President Trump held no nefarious intent toward Muslims when he signed the executive order?
Oh, he had some. Yeah, I believe.
Some? What does that mean?
I think, talk about employment law, mixed motives, right? I think part of it was nefarious. I think part of it was based on a belief, profoundly wrong, but a belief that by denying entry to these aliens will keep America safe. I think it's a mixed motive case.
Because the people who attacked us on 9/11, because of the 19 hijackers on 9/11, exactly 0 of them came from the countries that the travel ban applied to.
Oh, 9/11, right? That's not the only measure. And I think they picked those 6 countries, foolishly perhaps, because that was a country on a list that were previously given certain visa waiver exclusions. 2 of them are state sponsors of terror. I don't know why he picked those nations, but I'll admit, I think it was a mixed motive. I think there were partially nefarious motives.
I have a good idea.
Yeah.
One more question, or are you guys ready to run away screaming? One more?
So, should we expect, as partisanship increases and we further divide, the left gets more left, the right gets more right, should we expect that to kind of change the norms of how the judiciary operates?
Roy.
I am worried. I mean, I'm worried not just after last Thursday, right, and what we saw, and the specter of a Supreme Court justice who publicly believes that he's the subject of a vast left-wing conspiracy to obtain revenge for the Clintons. But I'm more worried about the lower courts and about the specter of polarization on the lower courts. So, we used to have the filibuster for judicial nominees. We don't anymore, right? And, say what you will about the filibuster. One of the things the filibuster ensured was judicial nominees tended to be pretty non-extreme in their views, right? How is it that someone with the record of a Brett Kavanaugh becomes a Supreme Court nominee? Because we live in a time where there's no filibuster. And where there's no sort of, and where it's just which party has enough votes. And we're seeing that in the lower courts too, right? We're seeing judges who I think quite probably wouldn't have gotten through in the time of the filibuster being confirmed, all over the country to district and circuit court judgeships. And listen, that's the way the system works. Those are the rules. But I worry that you're going to see the same thing happen in the lower courts that's happened in Congress, where 20 years ago, there were plenty of Democrats to the right of some Republicans, right, in the House especially, and today there are none. And I worry that you're going to see that with judges too, right, where if the whole thing is a race to the bottom, and our goal is just to get onto the court people who are the furthest to our side as we can, you're going to lose the sort of center ground, and that's when you're going to see an uptick in these kinds of attacks, justified or not, where every story about a judicial decision is going to be about who appointed the judge. And where that's going to be the bellwether for whether they're right, as opposed to our own independent assessment of whether we find the reasoning persuasive. And that scares me. And I think, there's no one party or institution that's to blame for that trend, but it's one we should all think about resisting.
I see what you did there.
And I mean that in the broadest possible sense.
I hope our courts don't enter a devil's triangle. Okay, I think it's all the time we have. that. Thank you. Listen.